Jocelynne, it's lovely to see you again, and thank you for joining us today on Salford City Radio.
It's really good to be with you. Yeah.
So I've got some questions here that Joe's given me to ask. So, what legally binding obligations does the UK undertake under the UN Convention on the Elimination of All Forms of Discrimination Against Women, which is CEDAW, and how are these incorporated into domestic law, if at all?
Well, the United Kingdom signed CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, in 1981. And they ratified it in 1986, and they signed the optional protocol in 2004. Now, those dates are really important because from 1981, it meant they made a commitment to live up to CEDAW. And in 1986, they made a commitment that they would incorporate CEDAW into domestic law. In 2004, what the optional protocol means is that they agreed that if a case was run by somebody in the United Kingdom and went through the process, which meant that the issues impacted on any provision of CEDAW and the case was held against them, they lost, then they could go to CEDAW committee and have the matter dealt with by the CEDAW committee. Now, to come to that issue first, if the CEDAW committee then said that the United Kingdom courts were wrong, the woman had to go through every level of the courts and exhaust domestic remedies, that is, remedies available in the United Kingdom, and then go to the committee. And if the committee said the domestic courts were wrong in the approach they took and that their decision was wrong and should be reversed, all that happened was that message went to the United Kingdom government, Westminster, and Westminster government could make up its mind whether it would leave the court decision, the United Kingdom court decision as it was, or it changed the law in order to conform to what the CEDAW committee said. Now, I don't know of any example in the United Kingdom where that's happened, but to quickly give you example where that did happen, it was not about CEDAW, but it was about another convention, and it's an Australian decision. But the state of Tasmania had left homosexual acts between consenting adults on the crime list, and two men took the case to the relevant committee of the United Nations, and the relevant committee upheld them and said that the state of Tasmania was wrong, that homosexual acts between consenting adults should not be criminalised, and the Tasmanian government changed it. So that's just giving it to you as an example of where that process can bring about change. But also that coming back to CEDAW, like other UN committees, the CEDAW committee cannot make the United Kingdom change whatever the legal decision has been of the courts, but they can say it's wrong and it should be changed. Now, as to the domestic law incorporation, the United Kingdom governments had contradictory positions on this. First of all, it said that it could not domesticate CEDAW until the devolved authorities agreed: Scotland, Northern Ireland and Wales. Now, that's actually just not true, because the government of Westminster, the Westminster Parliament, is the UK Parliament and has the power to say, well, we're going to domesticate CEDAW and it will cover the whole of the United Kingdom. Anyway, that was the excuse they used. But then it turned out that excuse was no good anymore, because we know that Scotland and Wales and even Northern Ireland are proceeding along the lines where they do want to introduce the Convention on the Elimination of All Forms of Discrimination. They want to introduce it into their own devolved authority. They can't do it because there's been in a court decision saying that Scotland could not do that, the Convention on the Rights of the Child. But anyway, now the United Kingdom, Westminster, has come up with another excuse. Now they're saying, the contrary to what they were saying before, that we don't need to put CEDAW in law because we've already there. And they cite the Equality Act of 2010 and they cite the Human Rights Act of 1998 and say we've done it. Well, of course they haven't done it, because if they're relying on those two bits of legislation, it means that they're relying on higgle-piggle, because it's higgle-piggle to have all women's rights. You've got to go here, you've got to go there, you can't go to one standing alone statute. So they're wrong. They're wrong also in that those two statutes do not incorporate the whole of CEDAW. There are whole big gaps that I could go into and cite to you, but I can just simply assure you that the United Kingdom has not carried out its obligation that it has agreed to since 1986 that it would incorporate CEDAW into domestic law. So it's simply not there, and they have to get on their bike and do it. Otherwise, they're in breach of their obligations under international law. Now, whether we can force them to do that, of course, in the end, it's a political decision. And unfortunately, the UN or the CEDAW committee hasn't got the power to force them to actually do what their obligation is under international law and their obligation because they have signed up to CEDAW.
Thank you, Jocelynne. Yes. What are the international accountability mechanisms for CEDAW violations, and what reputational, legal or political penalties does the UK risk by failing to comply with its obligations under the Convention?
In terms of what action can be taken if the United Kingdom doesn't live up to its obligations under CEDAW, first, there's a regular review of every country that signed up to CEDAW, and this regular review takes place every so often over the years. And in that review, the CEDAW committee, the CEDAW Convention on the Olympics, can say to the United Kingdom, you haven't done this or you haven't done that, or there's something wrong with what you're doing and you need to fix it. And so this happened, and I can give you an example where this was said, and the United Kingdom did take action, but there's somewhat of an irony of what they did. Northern Ireland had never had the Abortion Act of 1967 apply to it. So women in Northern Ireland had never, ever had the right to have a lawful health operation undertaken in Northern Ireland, which related to termination of pregnancy. So the women from Northern Ireland had to come to England or Wales to have it done. And in the 2019 review, the committee, CEDAW committee, said, you've got to do something about this. So what the Westminster Parliament did, and it's ironic what they did, the law that applied in Northern Ireland was the Offences Against the Person Act of 1861. And there are two provisions of that act which criminalised abortion. It criminalised the doing of an abortion by a medical practitioner or some layperson, etc. And it also criminalised the woman who underwent the abortion or endeavoured to do it herself. And what the Westminster Parliament did was repeal those provisions of the Offences Against the Person Act. But ironically, I haven't got a clue why and what the women in the Parliament at that time, there weren't many, but there were women in the Parliament at that time, why they didn't repeal those provisions in relation to England and Wales, because they still existed in relation to these countries. And it was a shocking oversight on the part of Westminster and every single member of Parliament in Westminster. They repealed them in relation only to Northern Ireland. Now, ironically, that meant that Northern Ireland had no criminalisation of abortion at all, whereas this country, England and Wales, continued to do so, because under the Abortion Act, though most people think that makes abortion legal, it does, but only in terms of an operation that's carried out in accordance with the provisions of that Act. And Section 5 of that Act did say that it was criminal to have a termination of pregnancy unless it was carried out under the exact and precise provisions of the Abortion Act. That's why women were being prosecuted in this country, particularly over the COVID period, because over COVID, it was well known possible to get access to a medical practitioner to have a termination of pregnancy. And say if you were a kid of 15 or so and you were pregnant, say you'd been raped or it was a so-called consensual pregnancy, well, how are you going to get access when there might be only one mobile phone in that household? I mean, I raised this when I was on the Cambridge City Council amongst the Labor group and was poo-pooed over it. Nobody took it up, shockingly. Anyway, this was the position in this country. Now, Ireland has subsequently brought in some provisions that do say that unless abortion's carried out under certain circumstances, it will still be unlawful. But there was, ironically, that period when Northern Ireland was more advanced than this country. Now, recently, this country has at last taken action. Westminster at last took action to make sure that at least some of the provisions that criminalised abortion are not still operational. But just to come back to this, that was one instance where government did take action because the CEDAW committee said something's wrong in what you're doing in your country. But if they said we're not going to do anything about it, CEDAW committee really couldn't do anything to say, well, you've got to, and you will suffer penalties if you don't. I mean, the penalties that countries suffer is, well, hopefully they're seen as a pariah in the international community because they're not following the principles and the provisions of CEDAW or any other international convention or treaty that they have agreed to enforce.
Thank you, Jocelynne. Now, has the UK ever been found in breach of CEDAW by the CEDAW committee or related UN mechanisms? And what actions, if any, have been taken in response to such findings or recommendations?
Now, this is a difficult question, Ian, because I'm unable to specifically point to any instance where CEDAW has been used by anybody in this country to go to the committee and to be successful. After the pensions group took their judicial review in 2019 and went all the way through the process, the High Court, then the Court of Appeal, and then the Supreme Court. And in the Supreme Court, they were dealt a blow because the Supreme Court simply said they were out of time. I mean, we can discuss that because it's a perverse decision, really. But after that, the people who were involved in that review, that judicial review, the case was Glynn and another, and they did lodge it with the CEDAW committee, but the CEDAW committee did not proceed to investigate or to say that what had happened in the Supreme Court was wrong. When I say the Supreme Court decision was perverse, is because in the original claim that the 1950s women had been discriminated against and that the government had not handled the matter properly, when that was put initially in the court, an extension of time was granted. The court said an extension of time is not necessary here, as indeed it wasn't, but they said, well, if it is, we'll grant extension of time. And so the case proceeded on all the grounds that were argued in the case. Unfortunately, the CEDAW provisions weren't raised, but explicitly, but it did, in a sense, impinge on what they ran it on was the European Convention on Human Rights. But of course, some of those provisions are ad idem with the provisions in CEDAW. And it went to the High Court on that basis. Now, the High Court found against Glynn and another who were running the judicial review. However, they granted the right leave to appeal on every single ground that had been argued. It therefore went to the Court of Appeal where, unfortunately, the same decision came down, in my opinion, wrongly, but there you go. And however, again, leave was granted to the applicants on every single ground to go to the Supreme Court. Now, what that means is that the High Court and the Court of Appeal, although they found against the applicants, they were saying that there are real issues here to be argued. And they were saying that it's not that the arguments that are put are airy-fairy or wonderland. They're real arguments, but they need to be agitated at a higher level because we have found that we don't consider that they apply, that they should win. And when it went to the Supreme Court, instead of addressing all those issues, the Supreme Court was one judge, was one line. There was no considered decision, no considered argument at all, just said it was out of time. Now, it's really very interesting because what is being said by the government, as I understand it, is, well, that they lost their judicial review. But they haven't actually lost their judicial review on every single ground, because the only place where they lost was the High Court and the Court of Appeal. They did not lose on those grounds in the Supreme Court. They just lost on the out of time issue. And the out of time issue really unable to be properly argued, because the point about that pensions case is that every time there's a reassessment of what those women who are in the 1950s group, what their pension is, that's a decision that can be challengeable. So the notion of out of time, well, it's not a substantive basis on which it could have been rejected or the appeal could have been lost. But anyway, that's how it is. And as I said, the applicants then went to the CEDAW committee, but the CEDAW committee didn't address it. The matter has also gone to the CEDAW committee more recently for a review, and the matter is still before the CEDAW committee. So we have yet to see whether the CEDAW committee will take it up, and if they do take it up, what the outcome will be. And unfortunately, if they were to find for the 1950s women, they can't force the United Kingdom government to do anything, but they can say that what the United Kingdom has done is unlawful in accordance with the provisions of the Convention on the Elimination of All Forms of Discrimination against Women. And if the government cares at all about its obligations in terms of having signed up to CEDAW, if they care at all about women's rights, if they care at all about discrimination against women, and if they care at all about the issue of pensions, the pensions gap, and what was going on with the 1995 Pensions Act, well, they should take action. Of course, it shouldn't take the CEDAW committee to get them to take action. They should be taking action off their own initiative, because it's the government, and it's every government since 1995 that's done the wrong thing.
Thank you, Jocelynne. And, it's really good to speak to you again today, and I hope we speak again very soon. And I want to sort of thank you for all the work you do for 1950s women over many years, especially with the judicial reviews and the reports and everything. I know that they value your work very highly.
Thanks very much, Ian. And I have to congratulate that group, the CEDAW in Law group, and its earlier iterations for the persistence that they have and the focus on the importance of now mediation, and that's the way this matter should be addressed, and that mediation is the first port of call, and one does not have to initiate legal action in order to get mediation. All the authorities, the courts and the government rules say explicitly and clearly that mediation is the first step in such a matter. And that's because the legal expense of initiating legal action is extraordinary. And of course, there would be expenses in undertaking mediation, but as nothing compared with a process of going through the court system, when mediation is there as a proper, legal, lawful, government-backed alternative. When I say government-backed, I mean they say that mediation is there to be used, but when it comes to the 1950s women, somehow that principle seems to be in abeyance.
Thank you, Jocelynne. Thank you very much.
Thanks, Ian.